Well, good afternoon, everyone, and thank you so much for being here. Thank you for joining me. Thank you for being part of this live stream. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here to talk to you about employment law and workplace rights and solve issues and give you some knowledge about this very important topic. Again, I'm Lior Samfiru with Samfiru Tumarkin LLP. They call me the employment lawyer. And once a week, sometimes twice a week, I log on right here on social media live to answer questions, to talk to you about your workplace rights. This is a live session. That means that you can join me on right now and you can ask me a question right now. It's going to pop up on my screen. I will read it and I'll answer it. So you have an opportunity to be a part of this, probably the most important part of the session, by asking your question. You can ask questions about your wrongful dismissal. You can ask questions about your constructive dismissal, about your boss, your ultimatum, the changes that your company is making to your hours, your days of work, your responsibilities. If you're being bullied or harassed or mistreated, the list is very long of things you can ask me right now. If you're dealing with a workplace problem, you do not need to deal with it alone. I've got your back. My team in Ontario, BC, and Ontario has your back. Ontario, BC, and Alberta, I should say, I'm sorry, has your back. So we're here to help you, to support you, to help you enforce those rights. And it can easily start right now by you asking a question about those workplace rights, by you getting the information that you need to better understand what this all means. Some people use AI. That could be hugely problematic. People contact me all the time after they've used AI and the information they get is not correct. Or you may go on Google and read some person's opinion. This is about getting the straight goods, the law, the facts. So ask your question about workplace rights, you'll get an answer. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And before I start answering questions, let me give you some other contact information. If you want to connect with myself or my team across Ontario, BC, or Alberta, so easy. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that right there on the screen. And when you go there, you'll have all the contact information you can ever need. Phone number, email address. You can fill out a form if you prefer. It's all right there so that we connect, have a private discussion, and I can roll up my sleeves and actually help you enforce those rights. But guys, right now, this is your live stream session with me, Lior Samfiru, the employment lawyer, dealing with employment law rights. So by all means, ask questions, get some help. Don't be bashful. Listening and watching is fantastic. Asking a question, of course, that much better. I think now is that time when we can start answering some questions. In the meantime, again, reminder, live stream, employment law, me, Lior Samfiru. Let's get to it. Our first question today comes from Nemos. I work in the trades and a coworker damaged a piece of equipment while I was supervising. No one was hurt, but the damage could cost hundreds of thousands. The company is sending us for drug testing, which will pass. I'm confident we followed all protocols, so I'm not worried about being fired. But I'm concerned the company might try to hold me financially responsible. Should I consult a lawyer now or wait to see if they pursue it? Any advice on how to handle this would be appreciated. So the reality is, no, they cannot actually hold you responsible unless you were doing something outside the scope of your employment that caused them this damage. Then no. If you, in the course of your employment, an accident happened that caused this damage, it's not something they can actually pin on you. So if they try to do that, they're not going to be able to. There's no legal mechanism for them to extract this money from you. So you don't need a lawyer at this point. Now, if at some point they come back to you with a demand or they say, we're going to start deducting money from your salary, can't do that. We have to have a chat at that point and I'll help you. One thing to note, of course, is your employer is not allowed to deduct money from your salary, even if you owe them money. In this case, you don't. But even if you did, they don't actually have a right to deduct stuff from your salary unless, of course, you sign something, written consent, giving them permission to do so. Otherwise, they can't, even if you owe them money. This is, by the way, important for everyone to remember there, that an employer can't deduct stuff from your pay without your written consent. So no, accident, I understand it happened. You were not drunk. You were in the course of employment. It's a situation that's unfortunate, but it's the cost of doing business. So they're not going to be able to force you to pay for that. If they even try, call me. Until then, you don't need to speak to me. But as soon as they reach out to you, if they do and they demand payment or try to extract payment from you, employmentlawyer.ca to connect with me. That's the way to go, and I'll be happy to help you. So thank you for that, Nemos. Now you know. And for everyone else, I think you see how easy it is to ask a question and to get answers. You just type it in, you hit enter, and I do the rest of the work. I tell you what you need to know. I provide help, support, advice, guidance. So this is the point of this entire session. If you're just joining us for the first time, thank you for being here. Welcome. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here live taking your employment law questions. I'm going to continue doing that right now. And of course, as I've said, as you're watching and listening, ask your question as well. Make it interesting. I want you to keep me busy. I want to be answering so many questions that I don't even know if I'm coming or going. So please ask those questions and I'll help you. All right, next question today. This one on Facebook, and it's from Ron. I work 12-hour shifts in BC from 7 to 7. We get in trouble for being even a few minutes late, like 7:03, but cross-shifting, sharing info with the next shift, takes 15 to 20 minutes and isn't paid. So they're asking you to stay longer, but they don't pay you. Our contract says 7 to 7 with no mention of staying late for cross-shifting, but it's expected. Now we're thinking of pushing back. Either we stop staying late or they pay us overtime. We're also considering filing a complaint with employment standards. What's your take on this? So what you didn't tell me is if you're an hourly employee or a salaried employee, okay? If you're an hourly employee, you get paid by the hour. Yes, they have to pay you for those 15, 20 minutes that you have to stay to inform the next shift as to what's going on, okay? They have to pay for that. If you're on salary, they may not have to. Depends on whether you cross the 40-hour overtime threshold. But if you have, then yes, at that point, they'd have to pay you overtime for that for sure. So those are the questions. Now, the other thing is you mentioned contract. You may be a unionized employee. If you are a unionized employee, you have to talk to your union. They're the only ones that can advise you. They're the only ones that can tell you if it's legal, if it's not, and what can be done about it. You can't really do anything on your own. But if you're not a unionized employee, if you're an hourly employee, they have to pay you. Does not matter what they want to do, they have to pay you. If you're not hourly, but you go beyond the overtime threshold, yes, they have to pay you overtime, time and a half. So that's how that works, of course. And happy to help you if you need this resolved. And you can, of course, reach me through employmentlawyer.ca. That's the way to go, employmentlawyer.ca. By the way, I think you see how easy it is to get questions answered. If you're just joining us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, here live with you, for you, helping you when it comes to anything and everything employment law. So all you got to do is ask a question. Pretty simple. You don't need to know the answer. You don't even need to know what all of that means. Just ask a question. I'll make sense of it. I'll help you. I'll tell you what you need to do. And of course, you can even ask follow-up questions. That's how easy and convenient this forum is to get your questions answered. If you're not sure, just ask a question. You may not know that there's something that can be done about it. Too many people assume the law doesn't really do anything, or the employers have all the power, so there's nothing I can do. All of that is wrong. You have more power and more rights than you realize. When it comes to employment law, the law does not favor the employer. The law favors the employee. So the laws are there to protect employees, not employers. So if you don't believe me, ask a question. Don't assume you don't have rights. Don't assume that there's nothing you can do. In almost every situation, there are many things that you can do, and the law does protect you and help you. So right now, on this session, you can ask questions and find out for yourself. And again, I'm Lior Samfiru with Samfiru Tumarkin LLP. They call me the employment lawyer, and I'm going to continue answering questions right here, right now. Adventurous egg. Love it. Adventurous egg. Never thought of an egg as being adventurous. I'm in BC. and my employer is trying to fire me right after I returned from medical leave, offering just $4,000. I have permanent nerve damage from a workplace injury and went through months of stress and harassment before getting benefits. I refused the offer and asked for $60,000 instead, 1 year salary, plus $10,000 for my injury. And they said I'd be speaking to a lawyer. Am I being reasonable, and is it worth taking legal action? Well, I can't tell you if you're being reasonable because you haven't given me any information about how long you've worked there, what kind of a job, what your salary is. You know, if your salary is $20,000 a year, that's different than if it's $200,000 a year. If you work there for 3 months, it's different than if you've been there for 25 years. So we have to kind of have that information to assess what you're owed. Here's what I can tell you. If they let you go, instead of bringing you back from a medical leave, that could be a human rights violation, depending on why. And if they've tried to find a job for you, that could be a human rights violation, which can entitle you to additional compensation. And again, unless you're working part-time, maybe a few hours a week, you're probably going to be owed a heck of a lot more than $4,000 in severance. And that could be a lot more. In fact, you asked for $60,000. You could be owed much more than that, right? But you haven't given me any of the information. But for you, Adventurous Egg, and for all of you, here's how you can find out right now how much severance you're owed. You can find that right now. All you do is you go to pocketemploymentlawyer.ca. You see that address on the screen, pocketemploymentlawyer.ca. And when you go to pocketemploymentlawyer.ca to access our severance calculator, you just click, first thing you'll see, severance calculator. You click on it and you're right there. When you're there, you answer a few questions. It's about 3 or so questions, and it's going to tell you how much severance you are owed. Maybe it's 2 months pay. Maybe it's 18 months pay. Maybe it's something else. It can even calculate that in dollars for you. It's so easy to use. It takes seconds. It's free, 100% free, not kind of free, 100% free. It's completely anonymous. No names, no phone numbers if you don't want, no email addresses if you don't want. It's all completely anonymous. So check it out. Don't take your company's word for it. And by the way, it's a very bad idea to make. So an adventurous, like you told the company, I want $60,000. Well, the problem with that is, what if you're owed more and they turn around and accept it? Okay, yeah, we'll pay that. And it turns out you were really owed $100,000, but you told them you wanted 60 and they accepted. Now it's too late. Never do that. So you don't do that until you call me, or at a minimum, go to pocketemploymentlawyer.ca and use the severance calculator. Okay, make sure you know what you're owed. You may also be owed human rights damages. So a lot of people think, well, I'll ask for more money. And the problem with that is, if you don't know how much you're owed, you may not be asking for enough. And the company turns around and say, oh, okay, no problem, we'll pay it, because you just saved them a bunch of money. Don't do that, okay? If you're owed compensation, if you lost your job, we need to talk about it before you contact the company, before you make them an offer, okay? Be smart, do the right thing to reach out to me, employmentlawyer.ca, and again, to use the severance calculator, pocketemploymentlawyer.ca. If you're just joining me, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin LLP, and I'm here on this live stream session, live, taking your questions. It's all about you and what you want to talk about in your workplace rights. So ask a question. I see a couple more questions just came in. I'm going to answer them right now, but I want your question as well. I don't want the session to end and you're sitting there watching and you didn't ask your question. Ask it, please. Help yourself. Help me help you. And make sure you get answers. Okay, let's continue. Alex has our next question. Alex says, my employer mandates that I carry a phone to take emergency calls throughout my shift. I work in a hospital. I carry it for the full 8 hours, and I have no ability to hand it off. There is an obligation to respond if it does. Does this violate Section 20 of the Employment Standards Act? Let's see if there's any follow-up here. So this is the 30-minute eating period to be provided. So during the 30-minute eating period, you can't expect it to do work. So if they're actually having you do work during that period of time, then that's illegal. If you simply have your phone, but there's nothing that you actually need to do, then no. So for the most part, yes, your employer it will be prevented and prohibited from having you work or do work during that unpaid 30-minute break. Now, if you have a union, you have to talk to the union. There may be exceptions to that. But if you're not unionized, don't. The law is very, very clear. And you're able to tell your employer, just so you know, I'm not going to pick up my phone from this time to this time every day because I'm on my break. And if they don't like it, there's really nothing they can do about it. Okay, so very important for this to be the case. You may decide, well, if they call me once a month during my break, I don't mind. That's your decision. But you're well within your rights to say, I'm not actually going to do work during my break. Those breaks are not nice to have. They're mandatory. And if your employer doesn't really give you a break, they're in breach of the law, and you can't be punished for not working during that period of time. So hopefully that makes sense, Alex. Follow-up questions, I'm right here. Need help? You can reach me through employmentlawyer.ca, and there's your answer. Thank you very much for that. And by the way, good question. Your question will be just as good. You can join me right now, ask a question. This is your live stream session with me, Lior Samfiru, the employment lawyer. And that's exactly what you need to do. To ask questions, you type it in. I see some more questions coming in. Let's answer them. You as well, ask your question. Don't be bashful. Bill has our next question. My employer has said that I am classified as a contract worker. How do I know if that's accurate? So I think what you mean is that they're calling you or classifying you as an independent contractor, not an employee. Well, if that's the case, and if you're wondering if it's accurate or not, I'm telling you right now, it's not accurate. There's no chance, because someone that's an independent contractor knows that they're an independent contractor. It's inconceivable to them they're not. Let me give you an example. If you just go home right now and your faucet in your kitchen is leaking, you're going to call a plumber, right? That plumber is going to come to your house. He's going to get his tools. He's going to go to your kitchen. He's going to fix the leak, going to send you a bill, and go home. That plumber, even though they came and did work in your house, they're not your employee. They're an independent contractor. That plumber doesn't go home and think, wait a second, am I Bill's employee or am I an independent contractor? They're running a business. They have a bunch of customers. They're running a plumbing business. So if you're running a business and you have a bunch of customers and clients, you're an independent contractor. On the other hand, if you work for one company, it's almost always going to be employment. If you have a boss, you go, you do your job, you go home, and the next day you come back to do the same thing, you are an employee. A contractor is someone that's in business for themselves. They run a business. They have customers, or they're trying to get customers or clients. So that's not likely you based on you asking this question. So what does that mean? That means you've been misclassified. You're actually an employee that's been called something else. Remember, it doesn't matter what you call yourself or what someone else calls you. If it mattered, everyone can be a contractor. The kids working at McDonald's, my legal assistant, people in factories, everyone can just be a contractor. Just call them that. It doesn't work that way, right? The reason it doesn't work that way is that the law decides that. I don't decide, you don't decide, the company doesn't decide. If you look like an employee and act like an employee, you're an employee. So this is likely an illegal arrangement. You're owed probably overtime and vacation pay and minimum wage. Of course, severance if you lose your job. And if you file your taxes as a contractor, CRA may not be happy about that. So there's various things you have to consider, all right? Happy to connect with you off air if you want to do that, Bill. And you can reach me, of course, through employmentlawyer.ca. Again, employmentlawyer.ca. Hopefully that makes sense. Follow-up questions, Bill? You got time. I'm still here. You can ask your question right now, and I will answer it. Thank you. See? Simple question, but important information to convey. Very common for people to be misclassified as contractors when they're not, when they're really employees. Thank you for that question. By the way, if you're still now joining us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you've reached my live stream session when I'm live answering your questions, telling you what you need to know about your workplace rights. And I can only do that if you ask a question. So please ask your question right now. I'll answer it, and I'll make sure you get all the information that you need. But right now, let's continue answering questions. Lindsay has our next question. I'm trying to return from mat leave, but my employer isn't giving me a date. How long can they keep me on leave? They cannot keep you on leave at all. You're the only one that decides when your mat leave is over. So they're not supposed to give you a date. You're supposed to give them a date. So you could tell them, just so you know, my mat leave is over September 2nd, whatever, and I'll see you September 2nd. Now, they may say, wait a second, September 2nd doesn't really work. We can do a 4th or for whatever reason. That's okay within a little bit amount of time. But it's not a situation where you contact them and say to them, hey, employer, when can I come back? And we'll get back to you, and they don't get back to you. That's illegal. That's potentially an employment standards violation, potentially a human rights violation. It could also be a constructive dismissal. It's illegal. So here's what I would do, Lindsay. I would simply tell them, here's when I'm back at work. You tell them, okay? So make sure you do that. And if they say no, but they give you another date that's very close by, fine. If they say, no, you can't, we'll get back to you, let me talk. Or you and I, let's talk and let me deal with it. Once they hear from me, a quick note from me, see how quickly all of a sudden you're back at work, all right? That's not legal. It doesn't work that way, that they decide when you're on mat leave and they're keeping you on mat leave even though you're done and you're ready to come back to work. Doesn't work that way at all. So Lindsay, hopefully now that makes sense. Do what I said, send that email. Otherwise, connect with me. You can connect with me, of course, through employmentlawyer.ca. Again, employmentlawyer.ca. Great question. And I don't know why employers would think that they can do that. They can just tell employees when they want them back and keep employees off on leave when the employee's ready to come back to work. Doesn't work that way. Not legal, problematic. All right, last 10 minutes or so of this session, but you still have so much time in those 10 minutes to ask your question. And yes, I will still give you that answer. If you ask a question right now, I guarantee you an answer. How's that? So ask it. Don't be bashful. And make sure that when we end this session, you've got that question answered, that you feel better about your workplace rights. Of course, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. And I'm going to go to the next question. This one is on YouTube or from YouTube, from ICE. I'm returning to a job where I've experienced ongoing harassment from a coworker. Despite reporting the issue in detail in June of 2024, the workplace did not begin an investigation until January 2025 and only concluded this month, finding no wrongdoing after minimal effort. I feel the investigation was inadequate and I've expressed safety concerns about working alone with this individual. Is my employer legally required to reinvestigate, and what are your options if they refuse to act further? So the question also becomes, who conducted the investigation? Did they do it themselves? In which case, if they kind of screwed up and they didn't do a good job, that's hugely problematic. Or did they bring a neutral, experienced outside investigator that concluded that nothing wrong has happened? If they did it themselves, the fact that they did a bad job, and we can show that they did a bad job, that could be easily a constructive dismissal. That may mean you don't have to go back and you can still get your full severance as if they've terminated you without cause. If they brought an outside investigator that concluded you did nothing wrong, you may not be able to do anything right now. But what you can do is go back to work, start keeping records of what happened. So if this coworker says something you inappropriate on August 12th, write it down, or better, send an email to someone confirming today at 2 p.m. this is what happened. Create that record. That's going to force them to deal with it. You have to create that record. You don't want it to be he said, she said. Always avoid that he said, she said type of a situation. Okay, so that's what you can do if there's an outside investigator that concluded that nothing happened so far. If it's the company that dropped the ball on the investigation, not someone from the outside, call me and let's talk about how we potentially extract you from that workplace with compensation, of course. All right, so that's what you do, ICE. You can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that. Really good question. I'm sure you're dealing with that. All right, I'm Lior Samfiru, the employment lawyer. Let's continue with questions. You can still ask yours. Mitch has our next question. Our facility is being shut down. we're being relocated to a number of other facilities and told that if we don't show up, we have quit. Do we have to accept a relocation change? Is there a limit to how far they can expect us to drive to a different workplace? So yes, there's a limit, but the limit has nothing to do with distance. It has to do with time. So it's not about how many kilometers, it's how much extra time is going to take you to get to that new location versus your old location. Generally speaking, it becomes a big problem for the company if the new location is more than an hour extra time than it would have taken you with the previous company or the previous location. So if right now to get to work, it takes you 15 minutes, the new location is going to take you an hour and 15 minutes, that is a problem. And potentially that's not a resignation if you don't go. That's a constructive dismissal. It's as if they've let you go and now you could be owed your full severance. Okay, so that's the difference. On the other hand, if it's an extra 25 minutes, unfortunately, it's not going to make you happy. And I get that, but it may not cross the level of constructive dismissal. So yeah, it's quite possible in that situation that if you don't show up to work, that would be a resignation. So that's just a general outline. There's exceptions and there's variations of what I've said. So the best advice I'm going to give you today, Mitch, is let's have a consultation. Before you say yes or no, or show up or don't show up to work, let's talk about it, okay? And you can reach me, of course, through employmentlawyer.ca. Again, employmentlawyer.ca. And happy to help you. Obviously, it's a big deal if now it's going to take you a lot longer to get to work. So happy to connect and talk about all your options. employmentlawyer.ca. Thank you for that. All right, let's get to see if we can do a couple more questions. Nicole has our next question. I've been employed for almost 15 years with no written contract. They have now presented me with a contract that makes the following changes. The days I work, my job title, the current benefits are decreased. I've been managing 2 other managers and overseeing 20 staff. Now they say they're strutting and each manager will manage their own department and I will not be overseeing anyone. So first of all, Nicole, these are just the changes that you've been able to identify. I can almost guarantee you that there's other bad things in that contract that are hugely problematic. I can almost guarantee you that your contract has what we call a termination clause, something that limits future severance. So potentially that could cost you tens of thousands of dollars. I'll give you an example. If it has a termination clause like that, if you were to be let go before you signed this contract, you'd probably be owed 12, 16, maybe even 18 months of severance. If you sign that, it could be as little as 8 weeks of severance. So, Nicole, no, not a good idea to sign this. Obviously, I would want to see it before I can say for sure what it does and doesn't do. But for all the reasons that you've mentioned and the reasons that I've mentioned, not a good idea to sign. You cannot be punished for not signing, okay? And if you don't sign, one of 3 things will happen. Either they'll back off and leave you alone, or they'll try to implement those changes to your hours and shifts without you signing, in which case it will be a constructive dismissal, or they may decide to let you go. But if they decide to let you go, they have to pay your full severance for your 15 years, which, as I said, could easily be as much as 18 months pay. So, Nicole, you want to connect with me. We want to have that chat, and I'm happy to help you. I'm happy to ensure that you don't get taken advantage of. But that contract is always a bad idea to sign once you've been working without it. You don't want to have a contract. That contract benefits the employer, not you. So thank you for that. All right. Last question, I think, of the day today, and that's from Timble. Can my employer my contract and performance expectations? I don't know exactly what you're saying. I don't know if you're asking if your employer can change your contract and performance expectations. I would have to see it, right? I would have to see how they're changing it, what changes they're making. You know, if your target was to sell 100,000 and now they made it 100,050 cents, for example, well, they can do that. If you had a target of 100 and now it's 2, well, that may be very, very different. So the devil's in the details. So I have to see what they're asking you to sign before I can tell you if you should sign and the impact of not signing. So Timbo, best advice, let me see it. Don't sign it, not without me seeing it. And you can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, fantastic, guys. You did keep me busy today. I appreciate it. This is the time we've had for today's session. Thank you so much for being here, for joining me, for asking questions, for entertaining me. All right, I do appreciate that. Really a privilege to be here with you every week. I'll be back here again very soon, as will my colleagues. But in the meantime, you don't have to wait till we're back here. You can connect with us now, today, if you want, through employmentlawyer.ca. I'm Lior Samfiru, the employment lawyer. I'll see you all again very soon. Take care.